Welcome, everyone. Nice to see you all here so bright and early. I'm Paul Smith from Henry Block in Washington, and I'm going to moderate the first panel today, which is on election law, kind of fitting for this year. And somewhat unusual for this preview. There is no election law case on the merits docket of the Supreme Court at the moment. So we're talking here about cases which could end up in the Supreme Court that are being actively litigated, in part because of the upcoming election and just because election law is sort of always being litigated these days, and in part because we have just come through the redistricting round. It happens every 10 years after the census. I want to jump right in. Could spend a minute just talking about last term to set the stage, though. We had basically one election law case last term in the court, which was an emergency appeal involving the Texas redistricting maps, which we got to brief in about 3 weeks over the holidays and argued a few days later. And then the court ended up having gone through all this Sturm and Drang, ended up essentially deciding very little in the case. This involved the question of what do you do when you have redistricting maps passed by the legislature. They are not in effect because they haven't been pre-cleared yet, and you've run out of time and you have to start running the elections, so a court draws the map, and should the court drawn map be the same as the legislative map that hasn't been pre-cleared under Section 5? The court said sort of, but not quite. It's kind of a middling outcome, not very interesting. The only other real development in election law last term was everybody got very excited about the Montana Supreme Court's, you could call it defiance of Citizens United decision that said, well, Citizens United is all well and good, but in Montana we have a particular history of corruption, unlike, say, Chicago or something, and we can't tolerate it here. So that was summarily reversed. With that background, let me introduce our very able and experienced panel, starting to my immediate right, Joan Biskupic, well known to all people who attend the preview, the Chief Justice last night. Has been covering the Supreme Court as a reporter since 1989, currently is the legal affairs editor in charge, is that correct, at Reuters, and author of 2 excellent biographies of Supreme Court justices, which I recommend to you, Justices Scalia and O'Connor. Next is Debo Adegbile, is that correct? Yep. Okay, acting president of the NAACP Legal Defense and Education Fund, and famous because in 2009 he argued the Mudno Section 5 case, and he didn't lose. And to my far right, in more ways than one, is Mr. Carvin, also last night from Jones Day in Washington. Mike and I run into each other fairly often in one courtroom or another every 10 years when the redistricting happens. I guess the most recent one was in Florida at the Supreme Court.
Don't remind me.
That's why I brought it up. Mike is obviously a very experienced and knowledgeable lawyer on the area of voting rights, election law, and a lot of other things as well. And so we have really excellent people to talk to you about what is likely to happen, again, in the area of somewhat speculative talk here in the Supreme Court as the term begins and we come up on the election at the same time. So why don't we start with the topic of Section 5 of the Voting Rights Act, the provision that covers only some states and not others, some jurisdictions and not others, and requires pre-clearance of voting changes. And Debo, since you did not lose in the Mudno, why don't we ask you to start off and talk to us about what's going on in the area of constitutional challenges to Section 5 and what's likely to end up in the Supreme Court. And we'll have others talk about it too, since this is a topic on which all members of this panel have interest and knowledge.
Terrific. Well, all the law students here should take that to heart. What your objective is in your first big case is to not lose. That doesn't necessarily mean that you win. But if you live to fight another day, you've done something. And so I commend that to all of you. I would not have had that result but for Neil Kotchal, who argued the case with me. And so here we are. The Northwest Austin case essentially decided it didn't decide the constitutional question, but it approached the constitutional question of Section 5, the constitutionality of Section 5 of the Voting Rights Act, and went off on a narrow statutory ground. Sometimes the way you plead your case matters, and although the purpose of the plaintiffs in the Northwest Austin case was to strike at the heart of the Voting Rights Act, they also pled a statutory alternative claim. And the Supreme Court, in a classic example of constitutional avoidance, went off on that narrow statutory ground, but spent most of its opinion talking about the constitutional issue that was not being decided. And the reason I give a little bit of that history is because that has brought us to where we are. And where we are is that we've seen more constitutional challenges filed against Section 5 of the Voting Rights Act between that decision in 2009 and today, as I said before you, then I think were probably filed between 1965 and the 2006 reauthorization. In a sense, the court said that the statute raises serious constitutional concerns, and what has been propagated by that decision is that every time there is a Section 5 claim, the parties, for good measure, tack on the, by the way, the statute is unconstitutional. And so courts have approached it in very different ways. Sometimes they bifurcate the issues and take up the statutory question first. Alternatively, they come to the heart of the question. And I want to talk to the case that presents only the facial challenge to Section 5 of the Voting Rights Act. So, for those of you who are not familiar, Section 5 is at the core of the Voting Rights Act, and it requires all or part of 16 states to submit their voting changes for pre-approval before they can take legal effect. If they meet a two-pronged showing, they can go into effect. If they don't meet that showing, which is a prong and a purpose and an effect prong, then they are objected to and can't go into effect, and the legislature or local officials need to go back to the drawing board. For most of our history, these pre-clearance determinations were made administratively through the Department of Justice, but the other trend that we've seen is that most of these cases now get filed through the alternative mechanism, which is before a three-judge court in the District of Columbia. And so we've seen a rash of cases there, but perhaps the most important is one that is being briefed right now to the Supreme Court, where the plaintiffs are appealing out of Shelby County, Alabama. It's a facial challenge to Section 5 of the Voting Rights Act. There are no alternative claims in it, and it cues up the question that was left open to a degree by the Northwest Austin case. That is whether Congress's decision in 2006 to reauthorize the Voting Rights Act is, and Section 5 in particular, was constitutional, and the sub-question in there, which is very important, made more so by the fact that Justice Kennedy was particularly interested in this aspect of the statute, is whether the decision to have Section 5 apply to certain states and not others can be justified today as it had been justified in the past. And so as civil rights lawyers, very often we like to look to precedent, and there are 4 precedents of the United States Supreme Court that have upheld the substantive remedy and a differential coverage regime. But in the last argument, the court was especially concerned and drilled pretty far down to ask whether Congress had looked at the way voting discrimination is manifesting itself across the country and whether they had adequately revisited this question. It's important to note that part of the statutory regime is something called the bailout provision, which allows jurisdictions that can show what is in effect a clean bill of health to move to be exempted from the act and bail out. And the court expanded that in the Northwest Austin case. So I think lots of people are thinking that the Shelby case will be the vehicle that gets granted for the Supreme Court to deal with the critical question about whether or not Section 5 is constitutional. The reason that would be important is because there are all of these percolating challenges that arise in the context of a specific type of voting change, a photo identification measure, a change to early voting, as Paul mentioned, redistricting cases. And if the court took any of those cases, they would have an opportunity to first decide the statutory question and maybe not reach the constitutional question, whereas if they grant in Shelby County, it's the whole enchilada, as we might say. And so I'm sure Mike will mention that there's another case that presents a constitutional challenge to Section 5 of the Voting Rights Act. It arises out of North Carolina. It is a case with special vehicle problems that Mike will explain why they're not vehicle problems at all. But you know, when I used to watch NFL games years ago, there was this great snippet they had where they would have a disputed play, not like the touchdown the other day that brought the refs back, but a play that was bona fide, disputed play, and then they would say to all of us before they went to the commercial, you make the call. You know, you got to be the ref, and then they would come back and they would say what the right call is. And so I will only say about Mike's case that it has certain vehicle problems. Mike can describe it to you, and then you make the call about whether Shelby County or the LaRoque, now Nick's case, is the appropriate vehicle to decide the question.
Yep, in doing that, Mike, do tell us about your case and the mootness issue. It's not an issue, I'm sure, but other people thought it was an issue. But also, if you could address, since you brought one of these cases, the question of why a facial challenge is appropriate here, given that courts across many different areas of the law have reluctance to take up facial challenges and insistence that you have to challenge laws as applied. That'd be something I'd be interested in too.
Right, so just to start with the procedural context, this is a case out of Kinston, North Carolina. The Obama Justice Department, in a very aggressive interpretation of Section 5, said that when this 65% black city decided to switch in local elections from partisan to nonpartisan elections with the support of the black community, this was retrogressive and violated Section 5. Why? Because white Democrats would have less incentive to vote for blacks if you took partisanship out of the mix, even though the vast majority of counties in North Carolina are nonpartisan elections at the local level. Apparently recognizing that this was not the best set of facts that they wanted to entertain in front of the Supreme Court, 3 years after the objection and 1 week before we were going to argue the case in the D.C. Circuit, the Justice Department woke up one day and said, you know what, it's really not retrogressive. We've got some new information. So you go ahead and make the switch to the nonpartisan elections. I suppose we could pretend that was a happy coincidence, but I think they were trying to moot out the case. The argument we're making to the Supreme Court is twofold. One, when, particularly to avoid adjudication, a government agency voluntarily ceases its prior illegal activity, as the Justice Department did here, the burden is on them to show that the case is moot, and they have to show that this will never recur again. Since Kinston is subject to Section 5, since we don't think they have the ability to do these retroactive, it's okay now kind of thing, they clearly didn't meet that burden, and the D.C. Circuit didn't even hold them to that burden. More importantly, regardless of whether or not our vehicle issue is would be a problem if we were just going up alone, Shelby County, I think, has already been indicated, is going to be taken, and our point is that you really can't decide the constitutionality of Section 5 if you just analyze whether or not continuation of Section 5 in 2006 was okay, because we, unlike Shelby County, are making an additional argument, which is even if continuing the status quo in 2006 was justified on the basis of conditions that existed in the South in 1965, Congress really exacerbated the unconstitutionality by actually raising the standards for pre-clearance. They added on this, they overturned an opinion called Georgia v. Ashcroft by the Supreme Court and imposed a quota floor under minorities' ability to elect. They said you can never diminish minorities' ability to elect through 2032. So they've gone miles ahead of what the old retrogression standard was. It was applied in a Texas redistricting case that I'll talk about to say that even any district that essentially elects a white Democrat, even if blacks are in the minority, the 9% district in Texas, you can never diminish the ability of white Democrats to win, since that's who blacks support in a general election. So we think, whatever you want to argue about how much the South has improved since 1965, there's no reason, it's utterly irrational and not congruent or proportional to impose a higher burden on the South in 2006 than you did in 1965. They also overturned a case that I had argued, which made it particularly annoying, called Bossier 2, which required the state to disprove any discriminatory purpose. So it put the burden on them as well. So again, ratcheted up the standard. So for the wonky kind of Supreme Court point is, we're saying it's not unlike Rutter and Gratz back when they were deciding the Michigan cases. Gratz, I guess, had not even been decided by the Sixth Circuit, but they went up and said, look, you can't really figure out the constitutionality of the system unless you look at both the undergraduate and law school together. And we're making a similar argument here that you really can't decide it doesn't make a whole lot of sense to go up and decide the question of whether the continuation of Section 5 is constitutional or unconstitutional without dealing with the question that is starkly presented as to whether or not the tougher substantive amendments in 2006 also survive constitutional scrutiny. In terms of why we brought a facial challenge, because all of these things are on their face, a question of whether or not Congress exceeded its constitutional powers. It doesn't make a whole lot of sense to say, okay, Kinston, North Carolina is out, but Charlotte, North Carolina is in. The point is that at its base, Congress had no power to selectively impose burdens that well exceed the 14th and 15th Amendment, because all they're allowed to do is enforce the 14th and 15th Amendment. And I don't think really it's even intelligible to think about Section 5, except in the broader terms of, did Congress have a congruent and proportional basis for doing so? And our principal argument in that regard is the one that's already been referred to, which is they decided who's under this regime, this very extraordinary regime, and who's not under this extraordinary regime based on election results from 1964 and 1968. I think the Namundo opinion was a pretty straightforward recognition that using 40-year-old election returns is not really a sensible way of figuring out current burdens or current situations. It was sort of an invitation to Congress to, I mean, it's already been pointed out. They say, look, we're going to decide it on statutory grounds in the window because we don't want to reach the constitutional questions. And then, it's already been pointed out, they give you 5 pages on here's the constitutional issues. And that extraordinary procedure by the court, I think, again, was an open invitation to Congress to say, look, can you come up with a formula that really distinguishes between the bad actors and the not-so-bad actors in this country? And Congress engaged in sort of an act of willful blindness, saying, no, we don't want to be confused with a lot of facts. We'll just stick with the old regime, and they haven't had a hearing, they haven't had any kind of effort to update in the wake of Namundo. So I think that will be a very important factor in assessing its constitutionality on its face.
Debo, did the D.C. Circuit add anything to the mix here in their opinion upholding it, or arguments, or any additional points that they tried to bring out? They must have anticipated that there would be certain things.
Absolutely. I think they did. They clearly framed the standard that was articulated in the Northwest Austin case, that the decision to continue Section 5 and Section 4 coverage must be sufficiently related to present-day problems and not simply based on the history. And Mike has, by my lights, misstated what Congress did in 2006. I was involved in that process and testified in support of the act and before both the Senate and House Judiciary Committees. And there is a common misnomer that Section 5 was passed in 1965, and because it used and drew upon election data from the election of 1964, essentially the coverage determination at that time was in 65 was made based on turnout and voter registration. If there was a turnout in voter registration that was below 50%, and the jurisdiction had employed a test or device, these tests or devices that had come to be known as intentionally discriminatory mechanisms to disfranchise African Americans and many Latinos in part of the country. If those two things came together, then the jurisdiction was covered under the Voting Rights Act, as Section 5 of the Voting Rights Act is initially articulated. And at that time, it wasn't that the turnout and the registration by itself was the problem that Congress was trying to cure. There was widespread and pervasive voting discrimination targeted at minority groups, and Congress used a particular mechanism to ferret out the places where it had been most insidious. The initial passage was for 5 years. Thereafter, Congress would review and see, had we made enough progress? And in each subsequent reauthorization, Congress didn't just look back to the 64 data. What they did is they said, what has the experience been in the covered jurisdictions since the time of the last passage or reauthorization? And in that way, the coverage determination going forward is not based on old numbers. It's based on those numbers which were a reflection of experience and intentional discrimination and what the subsequent experience has been in those areas. And so people like to say it's based on 1964. It denies the very substantial congressional record, which was recognized in Northwest Austin, and again in this recent opinion, where the court took a hard look at this coverage determination. And the coverage determination, I think it's fair to say that that coverage mechanism that I've described has always been imperfect. It's not a surgical tool that captures every place where voting discrimination will happen. It certainly was not so in 1965, and the leading decision in South Carolina against Katzenbach makes that point. But the court also said that it was a reasonable approach for Congress to take in light of the discrimination that they perceived and that was manifest. And so I think that what the court did in the recent Shelby opinion was to look back at the coverage decision, to look at the record, not to fly above the clouds and act as a Congress to decide what is the best policy for the United States of America, but to look at the record that had been assembled before Congress and to say that there were sufficient indicators that the problem was manifesting itself in a different way in the coverage jurisdictions than it manifested itself in other places. And very significantly, this observation does not mean that voting discrimination will not happen in other places. It means instead that the special remedy of having a preclearance requirement is necessary in these jurisdictions because of their special history of having a discriminatory voting change and then following it with another discriminatory voting change once the first one is cleared away. And the idea that's inherent in that determination is that other mechanisms, other parts of the Voting Rights Act, the Constitution, and state claims are enough to guard the franchise in other places.
Joan, you covered this story. Why don't you talk to us a little bit about what you learned when you traveled to Shelby County?
Yeah, I thought I'd go down there and actually see how this all started and what it was about. But one thing I just want to add to what Debo said about the D.C. Circuit, or the ruling that's going to be with the Supreme Court for the petition for cert here, and that's that Judge David Tatel, in writing that opinion, I think he went out of his way to acknowledge Northwest Austin as much as possible. And even during the oral arguments in the D.C. Circuit, he said to the Department of Justice lawyer, "You're acting as if Northwest Austin didn't happen. We want to account for it in the opinion." So I think that the way it's teed up is the strongest case possible given for the court now to take it, given what's happened, although I agree that it's a likely grant. The outfit that brought you this case is the same one that brought us the Abigail Fisher case from Texas. Edward Bloom had started the Northwest Austin case that was washed out on the bailout. And he took it essentially as an open invitation to find another jurisdiction that wouldn't qualify for bailout. And the reason Shelby County doesn't qualify for bailout and it would have this direct Section 5 challenge is also the one that I think could be the flip side of why this case might not be the best vehicle for it. There's a little city called Calera that's within Shelby County that had repeated voting rights violations, including one that just happened a couple of years ago, in which they've drawn new district lines, and the one African-American council member that had been there in Calera was voted out of office. Calera went ahead and held the election, even though DOJ hadn't pre-cleared it, so you had a lot of controversy over that. But what it did was for Edward Bloom, who is an advocate in Texas, originated in Texas, but is with the Fair Representation Project, got in touch with all sorts of lawyers to bring this, thinking, well, this will solve the problem that presented itself in Northwest Austin because it can't bail out. But it also, I think, could potentially be, Exhibit A for why Section 5 is still needed for the pre-clearance factor when somebody, not back in 1965, not even back when this was reauthorized in 2006, but in 2008, 2009, gets voted out of office because of the lines that were drawn. They were subsequently recrafted and he was reelected. Shelby County, it's also great that this comes from Alabama. It has all the, the resonances of why the Voting Rights Act was passed in the first place. We've got, Selma. We've got, exactly what got Congress to act. And I think that it does tee it up really nicely, and it does, given what the lower court panel wrote, present it as clear as possible about what has happened before and why arguably what they did in 2006, moving it forward and enhancing through the trigger of 4B, might still be needed. The SG's response has just come in. Some of you might have already seen it. And it is pretty vigorous. I think that there were some some flaws in the arguments before the DC Circuit, but I think that this is pretty vigorous on why they might not have to, why maybe this court wouldn't take it, and tries to address some of Justice Kennedy's concerns at the end about this disparity of, why the Pennsylvania voter ID law wouldn't be subject to preclearance where, provisions down in Florida in the 5 counties that are covered would be subject to it, and really takes it on in a way that probably won't be persuasive at this point, but could give the court a little bit of comfort in terms of the disparities out there. So I think that there's a lot more to this case than it might seem just in terms of the facial challenge, and I do think that when if it ends up being taken and presented and the court has a chance to look at what actually did happen down in that county, it will be an indication not just of elements of the New South that Mike referred to, but some echoes of the Old South too.
Joan, why don't we move on to the next? We got to talk about more than one case in this hour. The court actually did already decide a redistricting case summarily on the day of the first order list that came out at the end of the summer, Joan. That was the West Virginia congressional districting case where they reversed the district court. You want to just quickly summarize what happened there?
Sure, I'll do it quickly for everyone. This was the Tennant versus Jefferson County one. They issued a per curiam on September 25th. And in this one, there were basically what they held was that the 3-judge court below had misapplied the standard of Karcher versus Daggett of 83 and failed to give appropriate deference to the West Virginia legislature, which had redrawn the congressional districts for their 3 members of the House. And I guess the most significant thing for me, and the practitioners can jump in, is there were certain echoes of what we saw in the Texas redistricting case that was cited earlier, Perry versus Perez. The idea that there's you need to defer to the elected branches. The court said we're willing to defer to such state legislative policy so long as they are consistent with constitutional norms, even if they require small differences. The key here is that
Small differences in population.
the population variance here was 0.079, I believe, and they could have gotten it lower. They could have gotten it lower to meet the one person, one vote standard. And what the lower court panel had said here, the 3-judge court, was that if you can get it lower with computers, especially today with computers, then go for it. And what the Supreme Court said in its per curiam was, no, you don't have to. That 0.079 population variance, even though they could have achieved something better, they didn't need to go for it. And the Supreme Court essentially said that West Virginia was right to say, we've never split our counties up before. We have had a priority on now pitting one incumbent against another, and that was okay. So the district court panel had been much tougher in terms of the standard it had set. And again, I think that what this does with the Texas redistricting case we had earlier was just say that the Supreme Court's going to keep up the deference to the legislatures and allow them to take in a multitude of factors. And even though in this day and age, having computers that we didn't have in '83 when Karcher was decided, it still doesn't, it's not going to take us too much further from the original standard.
It is interesting from the point of view of people who have drawn maps for the last several decades after Karcher. In congressional cases, unlike state legislative cases, the usual practice is simply to bring down the population deviations to 0 by moving individual census blocks around to the point where you can get absolutely 0 deviation, because everyone figures you never know whether you're going to be able to justify the deviation. And any number of congressional maps have been held unconstitutional for having very, very small deviations in the range of 10 or 15 people. Which is kind of irrational, but that has been the custom and practice. Now, they applied what Karcher said and said a little bit less than 1% deviation is okay if you can point to justifications. And I think maybe this will encourage people to do that again, keep counties together, not pit incumbents together, things like that. But it is interesting to see that the message the court is saying is we're not going to be crazy about this 0 population deviation that's been done over and over again all over the country.
Yeah, I have a theory on this, which is Justice Alito's father drew the map in New Jersey that was struck down in Karcher. And other than, Paul's 1,000% right, everyone ever since then has just zeroed out these maps. No one thinks that a 0.79 deviation It's within the margin of error of the census data. It's going to be changed in a year. No one thinks it has any real world effect. It was just a bunch of people doing what Paul said was, well, we got a rule, let's zero it out. I can tell you, this was ex-party when we worked together with the Justice Department. Karcher came down in '83. Alito always thought it was one of the screwiest opinions he'd ever read. So I think we may have some move towards minimum rationality on this that will allow states to do sensible things like Paul was describing, not put incumbents together.
Or jagged piece of a county carved
Yeah,
out
just you literally you go get like 5 people. I mean, just silly stuff. So,
Paul, I think also that when redistricting is done, in a sense, the whole census provides us with the basis of a legal fiction that we proceed upon. So, you know, the count is not perfect in the first place. So the idea to use a flawed count is the best they can do, but nobody thinks that it's precise. But then to take something that is, by definition, imprecise and then require some precision in the legislative process seems to be a little screwy. But I will say that in the last decade, I think the court had some cases that, or courts had cases that were moving in the other direction.
the
And-
Pennsylvania case was
That
one.
was
That was
yeah.
your case, right? What was
They had
that?
a 20-person
Yeah,
deviation.
20 person, yeah.
Right, so this
Great
is
victory, Paul.
This is
It took
a,
about 10 minutes for the legislature to fix it.
a change in course, though, it seems.
Yeah, but it does seem like a change. The theory of why he would ratchet it down to a very, very small deviation, the court had this instinct that this would somehow lessen partisan gerrymandering and discipline the process. This has proved to be wholly and completely false. If you look at all the partisan gerrymandering that's happened in the last 2 decades.
And of course, they allow at the state level, they do give you the ±5, and so
That
The
doubles
partisan
the-
gerrymander theory can't work very well there either.
Why don't we go back to the area of voter ID laws, which there was some modest discussion of last night.
I'm sorry to have missed it.
I will give it back to Mike to talk about what's going on. We have some Section 5 cases and we have some other cases out there, and what's going to end up at the court eventually.
Right, I'll be more informational on this. Well, I'll introduce a little ideology at the end. The informational points is, as far as I can tell, the only 2 that are candidates for getting up to the Supreme Court in the foreseeable future is the Texas voter ID case, which about a month ago was struck down by the D.C. Circuit, the Texas voter ID law. About a week ago, they argued the South Carolina voter ID law. They're not under tremendous time pressure to sign that because South Carolina says they're not going to use it for the upcoming elections, but everyone anticipates a decision out of that panel relatively soon. As you probably know, in the Section 5 cases, these 3-judge court cases that decided it's not a cert petition, it's a direct appeal to the Supreme Court. So they'll either summarily affirm or take the case. I suspect they will take the Texas case. I suppose it will depend a lot on which way the South Carolina voter ID case comes out. You might have companion cases up there this term.
The Texas case, though, they're not ready to take it up yet because they're going to go back and rule on the constitutionality of Section 5, right?
No, I was just about to
Say, no. I think the timing on all this is greatly complicated by 2 things. One is what we just talked about, these bifurcated issues, where after you lose on the merits, you go back and start talking about constitutionality. In the meantime, we might have had some kind of decision out of Shelby County, or at least it'll be pending up there. So I think predicting whether or not they'll get to the merits of this, my own hope, of course, is this will all be entirely moot by the time it gets up to the court in May, because Section 5 will no longer exist by the time they get up to the court in May. So predicting how this will all sort itself out.
Is that information or ideology?
I'll say that was an empirical prediction. And look, I'll make 2 points there in terms of my empirical prediction. One is, I think I alluded to last night, I don't think it's fair to few. I think everybody would agree Justice Kennedy is not a huge fan of Section 5. He thinks that, as he wrote in the Ashcroft decision that was overturned, this has morphed into a law where you have to take race into account in every redistricting. He thinks it very much presses up against the substantive requirements of non-discrimination in the 14th and 15th Amendment. So he's very skeptical of the notion that it actually enforces them. He sees them in tension, not one enforcing
And
the other.
that really comes out of the Shelby Reno experience, where the Justice Department pushed people to draw these horrible, ugly districts back in the 90s.
Look, Paul and I have been doing this for a long time, and I'll plead guilty. I created half these crazy districts.
No, I mean, I suppose it's no secret, right? Republicans love these districts, and that's why in 2006 there was such strong bipartisan support for reenacting Section 5. Republicans like majority black and majority Hispanic districts because right next to them, particularly in the South, are majority white districts that they can win. A 25% district, for example, is usually going to elect a white Democrat in the South, but if you shift those blacks into an adjacent district would elect a black Democrat, then it presents a lot of opportunities for minorities. And no one thought, well, we did back in the 90s, when it was UJO v. Kerry, where the court sort of said, yeah, go do whatever you want. The Justice Department was very aggressive in terms of creating these districts, and I think we were all surprised in '96 that the court took such a strong view at Shaw v. Reno about the constitutional limits on these districts, and I think it's been reinforced ever since then that the notion that this is eliminating race-based impediments as opposed to granting preferences has taken hold at the court, that really what we're talking about here is a preferential regime, and I think they're suspicious of it. And the only other point I'll make again in terms of voter ID is you have not seen Section 2 challenges, which has a discriminatory result prong. In other words, you don't have to prove discriminatory intent. In all of the cases that you've, I think, read about in the newspapers have been in non-covered jurisdictions, Pennsylvania, Ohio. Florida's got 5 covered counties, but really the vast majority of the controversy's been in non-covered jurisdictions. You haven't seen Section 2 lawsuits. So what you have, again, to reinforce the point that I was making earlier, is a dual regime where these covered jurisdictions have a much more onerous burden put on them than the non-covered jurisdictions, even though it's hard to suggest that a voter ID law with substantial black population states like Pennsylvania is really any different than having a voter ID law in well, for example, Georgia, where the voter ID law was upheld under Section 2. So I think that this may reinforce to the court, particularly because the finding, just to be as clear as I can, in Section 5 case in Texas didn't find that the voter ID disproportionately affected minorities. In other words, it didn't find that blacks and Hispanics have fewer ID than whites. It said there was really no reliable evidence. So that was a stark illustration of the fact that the shift in the burden to sort of prove the negative, prove that this didn't have a disparate impact, is outcome determinative in a lot of cases, and that burden, that unique burden, is only placed on these covered jurisdictions.
Can I ask a question about timing? Hasn't Texas said that no matter what happens, this law won't be in effect in November?
Yes, so correct me if I'm wrong, in the covered jurisdictions, none of the voter ID.
As far as I know, that's right. It's South Carolina and Texas.
Yeah.
Right, so Pennsylvania is, as I understand it, purely on state law grounds at this point. They're trying to sort through whether or not it's okay under state law. But I am not aware of any pending federal voting rights challenges to voter ID laws outside of the covered jurisdiction.
Right. Well, I think there's an important point here, and I'll invoke history in the face of information and ideology. And the point is that the history of voting discrimination against minority citizens is not simply about partisan conflict. There is a long history of intentional discrimination targeted at minority communities. There is undoubtedly a partisan valence, but I think it does the history and the recent findings of Congress, it gives them short shrift to suggest that everything is about partisanship. To be sure, Paul and Mike work for parties and have expertise in being gladiators in the trenches of partisan interests. And there's nothing wrong with that. That's part of our system. But the Voting Rights Act does not articulate its purpose or its standards to confer benefits on partisans. And I tell you, as somebody who's litigated voting cases for more decades than you might guess, that very often both parties target minority communities for special disadvantages. And to the point that Section 5 or the Voting Rights Act is conferring benefits or preferences on minority communities, here I will come to facts. And the important fact is that in our system, we draw districts around people where they are and where they live. They live together because of certain reasons and certain history, and there are high concentrations of minority population that live together in areas that, because of our one person, one vote rules, however articulated, are entitled to have districts drawn around them. What the pattern had been is that legislatures across the country would do mental gymnastics to not draw districts where minority voters could control the outcome of elections, and would instead find ways to dilute the voices of these citizens, where in any reasonable approach to it, there should be a certain number of districts that are drawn around those people where they live for a lot of reasons. And so the idea that today this is all about partisan squabbling, I think disconnects the conversation to an important historical anchor that we need to look to, and that I think that the students should trace it through and don't always, today we talk about the partisan fight, but sometimes you have to look beneath. And if you're targeting minority communities to squelch their voices in our history, there's something else going on, and it's not just partisanship.
Well, that's a nice segue to the Texas redistricting case, Debo, where the court found intentional discrimination based on race against blacks and Hispanics in the way the districts were drawn in Texas. And the defense was, well, we did it just like we did when Tom DeLay was in charge. It was just to hurt the Democrats. It just happens that all the Democrats in Texas are black and Hispanic. So I don't know, you want to talk, that may be a wedge into that case, which is another case which could end up in the Supreme Court this year. It's a direct appeal from a 3-judge court throwing out all 3 of the district maps down in Texas.
Sure, so I think that case is probably a vehicle that better presents some of the issues that Mike spoke of in terms of how the substantive standard actually operates. In the constitutional challenge, there is this practice that DOJ has no longer objected to, that was sort of a one-off, and I don't know that the court is going to want to weigh into that. In the redistricting case, it's sort of the heart of where the act is, and figuring out how you measure retrogression. The effects standard under Section 5 of the Voting Rights Act is a retrogression standard, a worsening of position standard. The idea was that because discrimination was so persistent and adaptive, after decisions were won on a case-by-case basis, as I said, folks would look to circumvent it and find another way to achieve the discriminatory purpose. And so Section 5 was created to shift the burdens of time and inertia from the victims of discrimination to the perpetrators. And that's why the burden shift comes into existence. But in Texas, you have a very complex set of facts where you have multiple minority communities, you have different levels of racially polarized voting. You have an African-American voting bloc that does overwhelmingly vote African-American, but I think there are more distinctions in the Latino voters. I don't think that one can say that Latino voters are always voting Democratic. I think the history and the numbers are to the contrary, though there may be certain trend lines at present. Certainly there are districts that are Latino and are held by Republican electeds, but there are a number of issues about the interpretation of Section 5 and how the various standards work. What is retrogression? How far down must you be pushing at a minority opportunity district before you take it out of the zone of opportunity?
Another interesting retrogression issue in that case is related to congressional specifically. This is a state that got 4 extra congressional districts because they had more population, and at least the one characterization of the evidence is that they gave all 4 of those districts to Anglo control. And the defense was, well, we have the same number of minority districts we had last time. Isn't that okay? How can it be retrogressive?
Yeah.
And you want to talk about that?
Sure. So I think here is it's almost a master class in the weeds of Section 5.
It really is. And I'm going to have about 5 minutes to talk about it.
And I don't necessarily feel confident to offer it, but this is what I'll say. So the effects prong is this worsening standard. Don't worsen the position of minority voters in the face of the historical pattern. I think it's hard to use that effects prong to address this problem of where you have new districts and there are additional districts to be drawn. It doesn't appear on its face to be a worsening of position if you don't draw those districts in a way that they create opportunity for minority voters. However, there is the other prong that we have not talked about, which is the intent prong. And the important fact here is that the population growth in Texas is overwhelmingly because of minority population growth. So now I come back to facts. If the reason that Texas has or is entitled to more districts is because the Latino population in particular is growing exponentially. And then the legislature makes a decision in the face of those facts to draw more districts, but to make sure that none of them give voice to those Latino communities that are the cause of the additional representation in Congress, then I think there's a fair inquiry to look at what the motive of the legislature is in addressing these new seats. And I think it's an interesting distinction between how the effects prong might operate and how the intent prong.
Although the court actually held that under the effects prong, if you don't give additional seats in a situation like this where the denominator goes from 32 to 36, then you have actually given a smaller portion of all the overall state's representation to the minority group. So they actually held it under that analysis. It could be retrogressive as well. Mike, I know you want to weigh in on this case just for a minute, but I want you to recognize we have 4 minutes. So say anything you want about the Texas redistricting case, and then I want you to mention what's going on in campaign finance before we close this session out.
Oh, wow, okay. I'll talk like that guy in the Federal Express. Texas redistricting decision was a dream come true for me. I kept coming up with all these far-flung hypotheticals about how the new Section 5 would result in all these things that Justice Kennedy hates, and I didn't have to because now they put it right in front of them. Congress overturned Bossier 2 and Ashcroft, as I said, which Justice Kennedy really liked, to narrow Section 5 so it wouldn't be unconstitutional. He was very worried that in the LULAC decision that this would protect white Democrats like Marty Frost in a 25% minority district. The 3-judge court protected a white Democrat like Doug in a 9% black, 25% Hispanic district. He wrote Abrams v. Georgia saying, look, just because the denominator change doesn't mean you need to add this stuff on. 3-judge court said, nope, the denominator changes, you need to add this stuff on. He says, I don't like these coalition districts or these crossover districts, and he wrote Bartlett v. Strickland saying if you don't have 50% of the minority group, why would they be entitled to control that? The 3-judge court said, no, we really like coalition and crossover districts, and you got to add those as well if the denominator changes. So as I say, it would sort of be like a checklist of things that will annoy Justice Kennedy about his efforts to interpret Section 2 in a way that doesn't conflict with the 14th and 15th Amendment.
Section 5.
No, well, but he did it in the Section 2 context, and he imported it into Section 5, and now they've reversed all of that. You want me to talk about campaign finance?
At least mention the Danielle Hunt case.
Oh, yeah. So look, there's first of all, Citizens United was the simplest case in the history of the United States. Obviously, right? That you can't ban core political speech. Anyone who suggests otherwise just is really got to read the
Information.
That was a little bit odd.
Got to read the amendment. It said 3 basic things. You restrict spending on speech, you're restricting speech. Of course, that's true. You can't speak without spending money. You either got to rent the ad or build the billboard. Corporations obviously have First Amendment rights. You can't tell the Washington Post and the New York Times to endorse Mitt Romney, a law. It doesn't matter that they're corporations. Everyone understands that. And spending too much money on speech is not bad. It's good. We like speech. That's why we protect it. It's called the First Amendment. Obviously, trying to suppress people's speech, as Justice Brennan and Marshall stated quite eloquently, and Buckley is wholly foreign to the First Amendment. That's the Cliff Notes version of why Citizens United was correct. Because the liberal echo chamber doesn't like Citizens United, some folks in Montana said they could tell the Supreme Court they really don't like their decisions and they're going to decide them for themselves. This was the Montana decision that Paul referred to earlier. Montana has not been heretofore known as a bellwether of corruption. B, they couldn't produce any evidence of corporate expenditures in Montana because they haven't had corporate expenditures in Montana in the last 100 years, so they couldn't make a fact-based differential. And the 26 states that do allow corporate expenditures are no different than the 24 states that don't. So, and of course, this is a legal holding, not a factual holding, so that's why the Supreme Court said, no, we're going to summarily reverse it. The interesting case, the one I don't have an empirical prediction on, and I will be purely informational about it, is the one, is it Daniel Check? Daniel, so it was a Fourth Circuit decision. As you undoubtedly know, Citizens United said you couldn't stop corporations from making independent expenditures. The campaign finance law has always drawn a distinction between independent expenditures and contributions to candidates. A district court judge in the Northern District of Virginia said, look, if Citizens United said corporations can't make expenditures, I'm going to assume that they also can't make, that this ban on corporate contributions also goes down. the Fourth Circuit quite sensibly, citing this Agostini versus Felton case, said, look, if Supreme Court precedent's going to get reversed, it's going to get reversed by the Supreme Court, not by us. So they overturned what the district court did. I don't know. I suspect the court might take the case. I don't know if they really want to wade back into these waters at this point, and I'm about to say,
Do you know the status of,
I was
the
about-
cert petition was supposed to be filed, I think, this week.
so, hey, you're answering the question.
I was just about to ask, I don't know if it even got filed or not. These guys might be going to jail, so I assume they're sure throw in a cert petition. If
Came out
it's
in a
not,
criminal context.
If I had to bet, I bet they probably won't wade into this. I think it's tough to argue, since they have drawn this distinction between contributions and expenditures, that Citizens United necessarily presages a invalidation of the contribution ban, but I think that's anyone's guess.
Thank you. I'm sorry we ran out of time here before we could take any questions. Do you have one more comment you want to make, Debo? Or should we let Mike have the last word?
I'd like to preemptively
I actually think that I'll offer a fact, and I think you may agree. So the one thing that was missed in Mike's recitation of the parade of horribles about Texas is that before the reauthorization, the Supreme Court decided a case that involved the Texas redistricting plan, the Tom DeLay plan that was referred to earlier. And in that opinion, there was a sharp disagreement between the Chief Justice and Anthony Kennedy about what was going on in the legislature. And Anthony Kennedy said in his opinion, his controlling opinion, that how Texas conducted itself in the redistricting cycle bears the mark of intentional discrimination. So I think that although there are certain issues in terms of how the statute is being interpreted and whether the court got it quite right, underneath there is the larger issue that without the protection in place, it's clear that the trend line is unbroken in terms of targeting minority communities to have their voices reduced in the redistricting context, and that point is not missed on Justice Kennedy.
All right, well, we are going to go straight to the next panel. We just have a little stand-up and stretch break here, but don't leave the room unless you have to. But anyway, thank you.